Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Well, welcome again, ladies and gentlemen, to what I'm going to call the latest installment of the C&C Subrogation Factory. For anyone that has been listening to FIA and or has graced me with your presence at any of my podcasts or presentations, I tend to play with knowable undertones and themes, and I like to make corollaries to music. So if anyone remembers in the early 90s, the C&C Music Factory, I'm going to go ahead and take their namesake and use it. And of course, C&C stands for the two C's that are on this call: attorney Cindy Merrell, who's in our Louisville, Kentucky office, and myself, Chris Aguiar, an attorney here in our headquarters just south of Boston. Obviously, Chris and Cindy, and I just think that we should play with the C&C concept. What do you think, Cindy? I don't remember the last time I didn't do a podcast with you, and so I have to believe that there's something to this, that we must be like trending in the rankings or something.
I'm sure of it. I mean, we have to have music. You can't not have your own theme if you have a podcast, right?
Yeah, absolutely. I think if anyone's going to blow up besides Adam and his new venture, if you will, I want it to be us. So we're going to figure out some ways to really spice this thing up a bit.
Yeah, thanks, Chris, for that introduction. I wanted to talk today about something that has always been there, and I find that I'm running into it more and more, and that it is stop loss and how that fits into subrogation. So this is something I know that is near and dear to your heart, Chris, because you are the stop loss expert here. But I wanted to talk about what that looks like for a health plan. How does stop loss fit in our subrogation cases? And the easiest and most straightforward way to start with this is to give an example of a real life file and what happens when a plan member, has a catastrophic loss. So, let's have Bob. Our member is Bob, and Bob gets involved in a catastrophic injury in which we have a third-party vehicle hitting Bob's vehicle, causing significant injuries. As many of you plans know, what happens at that point, we're looking that is very likely that if, depending on your deductible, your stop loss policies, that stop loss will become involved. And once that happens and stop loss reimburses back the plan, stop loss very likely will have a right of recovery from the proceeds of that settlement, either directly from the third party, which is more rare. More likely than not, it will be from any recovery the plan makes back from the third party settlement. And what I come across many times is I have a lot of plaintiffs' counsel, so a lot of the members' attorneys, they somehow believe that just because a plan has stop loss, they are magically transported from the world of self-funded ERISA, which preempts state laws, into an insured plan. And that is just simply not the case. There is lots of case law across the country that says that the plan is still bearing that risk. They have no guarantee that stop loss will reimburse them. And the plan is, in fact, advancing those benefits pursuant to the plan document.
Yes.
Chris, you have any thoughts on that?
Yeah, I do. I was going to interrupt you, so fantastic to bring me in before I interrupted you. I appreciate that. Yeah, I do have some thoughts on that. It's so critical in these cases to understand what's going on. Obviously, the number one benefit that these self-funded plans have is the concept of preemption, the ability to preempt state law. And this whole debate about the funding status of the plan is incredibly important, because if at any point the plan or any portion of the plan comes out of that status and becomes insured, you really lose the ability to preclude things like the common fund doctrine, the made whole doctrine, which anyone that knows, and surely Cindy has felt this pain, you walk into a plan document and it doesn't have the appropriate disqualifiers for those provisions, and all of a sudden your slam dunk recovery case becomes to put it in the simplest of terms, right? But yeah, so it's unbelievably important on this issue of funding status of the plan, because to your point, Cindy, if you ever look at a stop loss contract, there are all kinds of conditions that have to be met before you qualify for the reimbursement. And as a plan, I recently got involved in a stop loss dispute a few weeks ago. I won't get into the gory details, but the stop loss carrier was doing something pretty aggressive surrounding illegal acts, exclusions, and whether or not driving without a license was sufficiently illegal to activate the illegal act exclusion. And so basically the stop loss carrier was refusing to fund the claims. Now you might be thinking to yourself, what do you mean fund the claims, Chris? This is a really important concept in the small to mid-market group space, because a lot of those groups have these advanced funding provisions. And if you kind of have an understanding of how this all works, you might be saying, hold on a second, Chris, are you telling me that the stop loss carrier actually pays the claims? The answer is no. What happens is the plan essentially enters into what's called an advanced funding rider. And what they do is a claim comes in and it hits either the specific deductible or the aggregate deductible. And essentially what the plan does is it makes its insurance claim to the carrier beforehand, right? They say, hey, carrier, we've got this claim. It's going to hit spec, but we don't have the adequate funds in our account. Can you fund? If you don't really understand the terms of that contract and you don't, hit the conditions exactly right, some of the more aggressive carriers in the country will not advance those funds. When I was on the phone with that plan, they were basically saying to me, Chris, if we don't figure this out, like this company's going under, everyone's losing their job. I and that plan's ERISA counsel were on the phone, and he was saying, can stop loss do this? And the answer is yes. And he said, why? We said, well, because the plan is governed by ERISA. The plan has certain fiduciary obligations and limitations that ERISA provides it, whereas the stop loss contract is not. The stop loss contract is governed by the four corners of that document, and ERISA has no bearing on it. So it's unbelievably important for plans to understand exactly what their contract says and what they have to do, because the last thing you want to do, and this is big as we start to shift into more innovative strategies like level funding, which again, we won't get into those concepts right now, but it's huge for these plans to understand that exact issue, that there are certain conditions you have to comply with. And it's that reality that sets up this exact situation that Cindy's talking about. That is this concept of funding and what changes the status of a plan from self-funded to fully insured. And to your point, Cindy, there's tons of case law on this that says a self-funded plan that purchases stop loss does not, simply by virtue of the existence of stop loss, become a fully insured plan. Now, did that ever change, right? What if the plan spec is $10,000 and the regulators would call this sham self-insurance, right? They would say you're not actually taking on any risk. But the key indicator is this. Yes, they are, because if the plan pays a claim or determines a claim is eligible under the terms of the plan and stop loss disagrees, guess what? No reimbursement is coming. And that is the reason that historically there really hasn't been anything outside of regulators trying to push this concept of sham self-insurance or the changing of the plan's funding status. It's because in reality, the stop loss carrier pays no benefits. The plan is at all times legally responsible for those claims. And if they rely on a carrier to advance those funds or make good on their promise, if you will, and they don't know what they're actually agreeing to, they could end up holding the bag. And in the case of that employer and a lot of those small to mid-sized employers, going under. So it's an unbelievably important concept that people need to understand why the funding status is that way, why they have certain protections, but most importantly, the very thing that protects them from insurance regulation in this arena is the thing that could get them killed if they don't understand the exact fact that the terms of that contract apply whether or not the claims are payable according to terms of your plan. So make sure you understand what you're signing. And this was an issue I was going to talk about a little bit later, but sort of just flows from it. Don't always just shop for the cheapest stop loss carrier. You get what you pay for. And sure, there are carriers that are more expensive, but there's a reason they're more expensive. They pay claims faster. They have less limitations and conditions. If you want to go and sort of bargain shop your stop loss carrier, that's fine. Just make sure you understand that contract and exactly what's required of you so that you as a plan don't get stuck in sort of the benefit and the burden, right? The very thing that's benefiting you, the fact that it's all your risk, is also the thing that could really hurt you if you don't manage it correctly. So sorry, I went on a little bit of a tangent.
No, that's okay. That's very helpful information, I think, for a plan, because unfortunately, many times we're on these calls with these plans and they haven't even really read their contract with their stop loss carrier until we're having these very difficult conversations with them. And that can be very tough because at that point, the ship has sailed. So, all right, let's get back to Bob's case. So Bob got hit by a vehicle, as you might remember, and he has catastrophic injuries, and stop loss has advanced benefits. They've reimbursed back the plan, or there's advanced funding rider in there. So the stop loss carrier has paid. And now we are working really hard on the subrogation portion of it. So then Bob is pursuing a claim against the at-fault party. And let's say the at-fault party only has minimum limits, and we are out in California, for example. California has $15,000 state minimum policy. So let's pretend that the only insurance out there is $15,000. And the plan has paid $500,000, and of that, stop loss interest is $400,000. Essentially, if you listen to the numbers, $15,000 settlement out there potentially, and $500,000 as medical bills, and stop loss is sitting there holding the largest part of that bag. Where we are is when we're trying to negotiate this, we can't unfortunately make that settlement fund grow. 99.99% of the time, is if there's no underinsurance, we are limited to that. It's not typically people who have minimum limits do not have a lot of assets in which anyone can pursue. So we're sitting here looking at these numbers: $15,000 settlement, $500,000 medicals, and then stop loss says, well, hey, we paid $400,000. What do we do about that? So the first thing we're going to do is we're going to look at your stop loss contract and see what that says. Most of the time, your stop loss contract is going to require them to be reimbursed from the proceeds of the settlement. So what we try to do is coordinate with the plan, and if they would like us to coordinate with their stop loss carrier, we try to do that to get at least some benefit back to the stop loss carrier. And unfortunately, in that circumstance, there's not going to be any additional reimbursement back to the health plan. And this is just something that is a reality, because when I start talking to these plans and we're on a call and they're already stressing that they're only going to possibly get, if there's only 15, we're likely looking somewhere between half the settlement and a three-way split. So they're looking about a $5,000 recovery. They're already stressing about that. But then I say, well, the news unfortunately gets a little worse, because all of this is likely going to have to go back to your stop loss carrier. And that, again, is based on your contract with the stop loss carrier. So there are just a lot of considerations out there for us to look at when we have stop loss involved in these cases. And we have to coordinate not just with the plans. We try to work with their stop loss carriers. Sometimes stop loss carriers will work with us and help us get the plan at least something back. And sometimes they just won't. And that is likely they're right in that case. So there's a lot of different things that we have to consider with stop loss and subrogation. Chris, I know that you wanted to also talk a little bit more about, in general terms, what a plan may consider when they are looking around for a stop loss contract. And not just as far as the funding, but what are some of the things that stop loss requires the plans to do? What have you seen out there?
Sure, yeah. I mean, perhaps the two most important things to think about, at least from a subro perspective, there's three issues, and then I'll talk a little bit about there's kind of two categories of contracts that we see from the stop loss carriers. The three most important things that I look at when there is a stop loss issue on a case is, number one, does the stop loss carrier have its own exclusions or not? If they don't have its own exclusions, now you have to be conscious of, what does the contract say about interpretation? What right, if any, do they have to interpret? Are they vague about that? The vaguer the language, the more squirrely and flexible the carrier can be. And when I mean flexible, I don't necessarily mean in a good way, right? What I'm saying is, if there's no information in there specifically saying we exclude this, well, can they turn around and interpret your language to the extent that your language isn't clear, right? You really want to be in lockstep with your carrier philosophically on that. And then the third important issue that comes up often is, how are legal fees handled? And specifically what I mean by that is the cost of recovery, right? So some carriers will basically say that the plan owes them the net of the recovery. So what that would mean in this case, for example, the plan paid $15,000. Let's assume, for the sake of argument, that the plaintiff counsel's lawyer is not fantastic at his job and agrees to give us the whole $15,000. What I just gave you folks was a unicorn scenario So please do not take to the bank that I can get you $15,000 on all your cases. For the ease of the discussion, let's say this lawyer says, we don't want to fight with you, ERISA plan. Here's your $15,000. Does the plan owe the stop loss carrier $15,000, or do they owe the stop loss carrier $15,000 minus whatever fees we took via as their vendor to get them the $15,000? Let's just say for ease of numbers, again, our fee is a third. Our fee is not a third in a lot of cases, though it can be as high as a third in some cases. Or does the plan owe $10,000? In other words, does stop loss give the plan a credit for the fact that the plan essentially had to go get this money and they had to pay someone to do it? Or does stop loss say, we don't really care that you owe fee of 5, we want 15, such that now the plan is actually out 20, right? So that's the three perhaps most important issues that come up in the stop loss arena that plans need to think about, not only as they're addressing sort of subro issues, but also as they're addressing determining whether the claim is payable and what impact, if any, will that have on their potential stop loss reimbursement. When you're looking at stop loss contracts, specifically with respect to subrogation, there are two types of contracts, and there's really two types under one of the categories. So there's three types, but they fall into two categories. And one is what I call the if-then contract, and the second is assignments, okay? So one, the if-then contract is basically the carrier says it is the plan's obligation to pursue third-party recoveries. If the plan chooses not to, then the stop loss carrier has the right to step in the plan's shoes. That's an if-then. That's an important one because, again, it is your obligation plan to go after the money. Now, if you choose to go after the money, are you in violation of your contract? Maybe. At a minimum, what you need to think about is, we don't really want to go after this money. Bob is a super important employee to us. He was really messed up. We'd rather he have the $15,000 to do whatever he needs to do on his home. So if the plan takes that position, does that mean they're in breach of contract? Maybe. So what you want to do as a plan is anytime you're making a decision on an if-then that will impact stop loss negatively. And in this case, the reality is if you reduce at all, you are not reducing with your own money. You're not playing with your own money. You're playing with somebody else's. You want to make sure stop loss is on board. Then you have the two assignment types. One is an automatic assignment. And basically what the stop loss contract says, if you have a third party claim, you automatically assign your right of reimbursement recovery to stop loss. In theory, that means the right of recovery comes into the plan and they step out of the way and say, here you go, stop loss, automatically, okay? Now, whether or not they always enforce that or allow that assignment is anyone's guess, but that's contractually what it looks like. And the third type is also an assignment contract, but it is a assignment at our request. So essentially, it's the plan that's supposed to do it, but the stop loss carrier can at any time say, you know what, plan, we want this case. We want you out of this. The important thing to think about in everything related to stop loss is the relationship, the relationship, the relationship. And Cindy sort of touched on this a little bit. Plans really should view these cases as found money. The plan already got its reimbursement when it got $400,000 back from the stop loss carrier. That $15,000, I tell plans all the time, I get it. I understand that you feel like you should be getting some money back here too. But the fact of the matter is you already got $400,000. And so what's more important to you, having a good relationship with your stop loss carrier or getting a small amount of money back on what was a very large loss that someone else essentially reimbursed you for?
Chris, on that, I would say that we have that conversation a lot, and that is a very tough conversation for plans.
100%.
So if you have a concept before you have a case like this happen, unfortunately, I hope you never have something like this happen and have to be in this situation. But if this happens, it's much easier to understand it before than after.
100%. And the other point I want to make, and then I'll kind of pitch it back to you, Cindy, is again, this concept of relationships, right? Sometimes when the numbers get bigger, meaning let's say in this case, the plan spec was $250,000, such that the reimbursement to the plan was only $250,000. Because remember, in Cindy's hypothetical, the plan paid $500,000. If the plan had a $250,000 spec, that means they paid every dollar up to $500, then got reimbursed $250,000. If you have a good business relationship with your stop loss carrier, and the key to a good business relationship often is, are you currently one of their clients? And how long have you been one of their clients? Are you up for renewal with them, right? These are the things that you want to think about. Often the carriers that are very client friendly will, in situations like this, be more amenable to, you know what, why don't we split that $15,000 50-50? or whatever the recovery might be. They may be amenable to a proration or some amount going back to the plan, even if it's not a true proration. Again, it's so important to understand what you get for what you're paying for, number one. And number two, to the extent that stop loss is important to you. And I would tell you that small to mid-market plans often cannot survive without stop loss. Now, in the long run, chances are they could, but on a year-to-year basis, and I have clients that have been self-funded for a very long time and have decided we don't need stop loss. Over time, we're going to be better off if we don't have it. I don't recommend people do that unless they know exactly what they're looking for and they have the cash flow and wherewithal to stomach some of that risk. However, those small to mid-market plans need to be conscious that that relationship with your carrier, both from duties and obligations in the contract and just what kind of consideration you'll get in tough situations like this, where maybe the plan feels like it has to pay, but it's concerned about that reimbursement, or there's some issue or concern that they'd like to see some of those recoveries back. How good your relationship is with your carrier is such an important piece of this puzzle. So, plans should take that for whatever it's worth it and whatever fits with their philosophies. But those are important things that plans want to think about, both pre-subro and generally, and also within the context of their subro program. Back to you, Cindy.
Thanks, Chris. Well, those are a lot of things to consider. And the first step is to make sure that you've read your stop loss contract. And if you have any questions on those, the FIA group is more than happy to assist you with that. So at this point, I think we understand that whenever stop loss is involved, it just becomes a little bit more complicated. But the good news is, in the end, the plan, you are not losing your preemptive rights in a lot of those no subro states. So that is very good news. Well, thank you all very much for joining us today. And I have enjoyed our conversation on stop loss. And if you have any questions about this, Chris is our expert as far as stop loss and subrogation. He is very knowledgeable and has taught me a lot since I've been here with that. If you guys have any questions, give us a call. Otherwise, I look forward to talking to you again on the next C&C Factory on empowering plans with the FIA group.
Thank you so much, everyone. Have a great day.